the other day that made me laugh. It was a lawyer's billboard ad, and I don't know whether it's true or not, doesn't matter. But the billboard said, just because you did it doesn't mean you're guilty. And everybody had a good laugh at that. But I started thinking about it, and it raises a very serious point. That is true. Just because you committed a criminal act does not necessarily mean you are criminally guilty. How is that possible? Well, I tell clients all the time, there's a difference between factual guilt and legal guilt. And people will come to my office and say, I did this thing and therefore I'm guilty. And my response is, whoa, hold on a minute. Just because you think you are factually guilty does not necessarily mean the law will deem you guilty. I differentiate between factual guilt and legal guilt. There are two ways that somebody can be found legally guilty. First, you have to have a criminal act, what we call an actus reus. You have to physically commit the act of the crime. But you also have to have what we call the mens rea. You have to have a guilty mind. You have to have the idea that you are going to commit the crime. And without both of those, in most circumstances, you're not legally guilty of committing the crime. So, when you think that you're factually guilty, you still have defenses. Let me give you an example. You may have possession of contraband in your house. Okay, you are physically committing the act of possession of, say, cocaine. Well, the police come storming into your house without a search warrant, which they need. They seize the cocaine and arrest you. Well, I am going to move to suppress that evidence. It will be dismissed. The state won't be able to use it, and therefore the state will not be able to prove you guilty beyond and to the exclusion of every reasonable doubt because they don't have the evidence. So a situation like that, you are factually guilty of possession of cocaine, but you will not be found legally guilty of possession of cocaine. That's the difference.